start coming. Okay, good afternoon and welcome to all of you who have joined us for today's event where we have Professor Dr. Prabhash Ranjan, who is presently Vice Dean Continuing Education, Jindal Global Law School, Jindal Global Jindal Global University, Sonipat, Haryana, as our speaker for today, and who will be speaking on India and bilateral investment treaties, refusal, acceptance, and backlash. This also happens to be the title of a book that he has recently published from Oxford University Press. Dr. Prabhash Ranjan, Professor Prabhash Ranjan needs no introduction. Yet, formally, as moderator of today's event, I am going to say a few words about our speaker for today. Professor Prabhash Ranjan has done his LLM from SOAS, University of London, PhD from King's College London, and he has taught at NUJS Kolkata, NLU Jodhpur, South Asian University, New Delhi, and he is presently teaching with Jindal Global Law School. Sir has been visiting fellow at institutions of repute like Brookings India, Lauterpacht Center of International Law, and so many other places. We all know him in the recent past because of his opinion pieces that we get to see or get to read almost every week. So that in itself is an example of how much effort he puts in. And he is not somebody who is only into writing opinion pieces. Just yesterday, he has one of his papers published in the Journal of World Trade on TRIPS waiver in respect of the recent controversy about the vaccines for COVID-19. Sir has been a prolific scholar, especially of international trade, international investment law, and in particular bilateral investment law, bilateral investment treaties, and the law. But of late, especially in his op-eds, we have found somebody who is also educating us on general principles of international law. So, for example, even on Ukraine's Russia aggression on Ukraine, we have only Prabhash Ranjan telling us about the legality of it in international law. So that is something which which is commendable for a scholar, especially of international law in India, a discipline which is not so sought after, because probably people think that it is not something which they can practice, and that's why we do not have that kind of attraction associated with this discipline, especially in India. So in that sense, Professor Ranjan has been a torchbearer, not only of the discipline of international law in general, but also perhaps as the conscience keeper of the Indian Legal Academy. So without much ado, I would now like to formally give the stage to Professor Ranjan to deliver his talk on India and bilateral investment treaty. Sir.
Thank you so much, Manvendra, for those very kind words, which I don't think I deserve. But nonetheless, thank you very much. I'm extremely grateful to Dharmashastra National Law University for giving me this opportunity to talk about this topic, which, as Manvendra mentioned, is also the title of the book which I wrote. This was published about 3 years back by Oxford University Press. Before I come to the book, just a few reflections on, why it is important for academics to write op-ed articles or express their opinion in national dailies. And you will find academicians having different views on this. So there is one school of thought which believes that academics should not be writing popular articles. They should only focus on research which is published in academic journals. And there is another school of thought which kind of argues that no, you should contribute not just to journals but also in terms of popular writing. And I clearly subscribe to the second school of thought. And my role model here is someone like Pratap Bhanu Mehta, who is not in law. But if I have to take a name of a legal academic, I'll say Upendra Bakshi, who has written several op-ed articles. And the reason for this is because I believe that only specialists will read journal articles. Only specialists in your area will read books. But if you want to take the subject to the masses, then you will have to contribute in popular writing as well. And newspapers and other kinds of avenues which are today available are a great opportunity for you to popularize your subject. As Manvendra mentioned, that international law is not sought after. In fact, I'll say law itself as a career option is not very sought after. And the reason for this is that we don't have too many role models as law professors. So I recently saw this movie 83, and I kind of I can't resist myself from giving this example that one of the biggest service that Kapil Dev and his generation of cricketers did was that he enabled a new generation of cricketers to come up, because till that time no one thought that playing cricket can be a full career option. So therefore we need to create more and more role models, which will then sort of become something that people, younger students, can look up to, and that will ensure that the quality keeps on improving with each passing day. Okay, now since Manvendra talked about this, so I thought I'll just very briefly offer my reflections on this point. Coming to the topic on which I want to speak, India and bilateral investment treaties, refusal, acceptance, backlash. Now, as the title itself indicates to you, I'm going to talk about three different phases of India's experience or India's interaction with bilateral investment treaties. But before that, I'll very briefly talk about what are bilateral investment treaties, since I presume that many of you might not be well versed with the area of international investment law. So bilateral investment treaties, to put it very simply, are treaties which are signed at the bilateral level with two objectives. First, to promote, and second, to protect investment. Now, how do they promote investment? When countries enter into bilateral investment treaties, they accept certain obligations as part of international law. And the obligations are that they will offer treaty-based protection to foreign investors. Now, this protection which countries are willing to offer to foreign investors is in addition to the protection that they already offer to them as part of their domestic laws. So you will have several provisions in the company law, for example, that also apply to foreign investors. But what an investment treaty does is that it provides an extra layer of protection to foreign investors. And by offering this extra protection under international law, countries believe that this would induce foreign investors to invest in their country. Now, why do countries want to attract foreign investment? There's huge economic literature which tells us that foreign investment brings in several benefits. Of course, this may not be true in every single circumstance, but by and large speaking, foreign investment brings in significant benefits to the host economy, and therefore countries are willing to attract foreign investment. So a bilateral investment treaty basically provides the conditions under which foreign investment will be made, and what are the obligations that the state has accepted vis-a-vis the foreign investors of that country. Now, a very important feature of these bilateral investment treaties is the investor-state dispute settlement mechanism. What it basically means is that whenever any investor believes that the host state has taken an action which, in the view of the investor, breaches the country's treaty obligations, then the investor can straightaway commence international arbitral proceedings against the state. Now, this is an aspect or a feature which you will generally not find in the larger body of public international law. In the larger body of public international law, it is always a sovereign which challenges the actions of another sovereign as a breach of international law. So at the ICJ, for example, you and I as individuals cannot bring a claim against a state. Only a state can bring a claim against the state. Same goes at the WTO's dispute settlement body and at several other international tribunals. But within bilateral investment treaties and within the international investment law, there is a exception or a separate category created where investors can actually directly bring claims against the state. And this aspect makes this entire feature, this entire topic of international investment law that much more interesting and exciting, or even problematic, depends on how you look at it. Okay, with this brief introduction about investment treaties and investor-state dispute settlement, let me now divide my talk into three parts, and I'm going to focus on each of these three elements which I mentioned: the phase of refusal, the phase of acceptance, and the phase of backlash. Now, in my book, when I argued about these three phases, I have divided this into three time periods. And I call the time period from 1947 till 1990 as the phase of refusal. Now, why do I call this as the phase of refusal? Because during this period, India did not sign or enter into any bilateral investment treaty. India was averse to accepting or recognizing international investment law. India believed that all aspects of foreign investment regulation in India should be governed by domestic laws. And this was the period when India had emerged out of its colonial rule. So it's not surprising that a country which was coming out of 200 years of colonial rule will obviously not openly accept or embrace foreign investment. After all, the Britishers came here as traders and as investors, and then they colonized the entire country. So from that experience, India, and not just India, several other developing countries, or the third world states as they are called, they did not accept international investment law, or had their reservations vis-a-vis international investment law. But this does not mean that, globally speaking, no investment treaties were signed from 1947 till 1990. In fact, the first bilateral investment treaty was signed in 1959 by Pakistan, or between Pakistan and Germany. And from 1959 till about 1989, 400 odd bilateral investment treaties were signed. But India was not one of the countries which signed the investment treaty. So this phase of refusal, I have divided in my book into further two sub-periods. The first period is from 1947 till 1965. And this is a period when you had Jawaharlal Nehru as the Prime Minister. Now, contrary to popular perception, Jawaharlal Nehru's India was not averse or not opposed to foreign investment. And this is something which I found very, very interesting during my research, that India at that point of time had a relatively liberal and open approach towards foreign investment. And the reason for this was because foreign investment was seen as a very important source of foreign exchange. Now, India, which was a country coming out of 200 years of colonial rule, obviously needed foreign exchange in order to import several things, including food at that point of time. And foreign investment became a very important source of that foreign exchange. So India did not shut its doors to foreign investment. But of course, whenever foreign investment came in, it was subject to certain restrictions, to certain regulations. And these restrictions and regulations basically were with the idea of ensuring that foreign investment does not become the dominant part of the domestic economy. It just plays a role in terms of bringing in foreign exchange. It's very interesting for us to note that during this period, from 1947 till 1965, if we look at what was happening in other countries, for example, if we look at what happened in China or what happened in USSR after the Russian Revolution, in these countries, there were mass nationalizations of foreign investment. In fact, in most communist countries, wherever nationalization took place, the foreign investors were not even given due compensation for their property or for their investment being taken by the state. But it's very interesting that, notwithstanding India being inspired by USSR and its 5-year plans, etc., India did not go down that path. India did not indulge into this mass nationalization of foreign investment. And as I document in my book, there are several instances of these debates within the parliament where the Prime Minister himself openly and categorically said that this talk of mass nationalization is of no use. It will not bring any benefit to the country. And also, let's not forget that when the constitution was adopted, right to property was recognized as a fundamental right. And therefore, even if you indulged into nationalization, you will have to pay compensation to the investor. And it was rightly believed that instead of squandering those resources in giving compensation to the investor, it might be better to use those resources into developing newer industries under the public sector. So this is a very important defining characteristic which puts India into a different league in comparison to countries such as China, USSR, etc. In India, there were no instances of mass nationalization of foreign investment. There were only few instances where nationalization did take place. For example, the Imperial Bank of India, which later on became the State Bank of India, was nationalized. You had British shareholders as part of the Imperial Bank of India, but due compensation was given to these shareholders for nationalizing their investment. So there were no nationalizations during this period. Another very important aspect, which several international lawyers, especially the 12 lawyers, have not highlighted for whatever reason, is that during this period, India also signed two investment guarantee agreements. These were not bilateral investment treaties, but two investment guarantee agreements with US and West Germany. Now, what did these investment guarantee agreements do? They basically provided certain guarantees to the foreign investors if the foreign investors from these countries were willing to invest in India. Now, if these investment guarantee agreements contained a few other features, then historically we would have said that India also entered into bilateral investment treaties during that period. But these investment guarantee agreements fell short of a full-fledged bilateral investment treaty. But nonetheless, they provided certain guarantees to the foreign investors, which also shows that India did not have any blind ideological or doctrinal opposition to foreign investment as such, as it is often portrayed or presented to us. The damage was actually done post Nehru's death, and this was when Indira Gandhi became the prime minister, the period from 1966 till 1979. And this was a period which, as we all know, was a period marked by what is today today popularly known as populism. So India's first populist leader was actually Indira Gandhi. This populism basically included at that point of time a very leftward shift in economic policy. So while Nehru had not nationalized banks, Indira Gandhi went down that nationalization route. Banks were nationalized, general insurance was nationalized, and several other things were nationalized during that period. All of this was done through ordinances, which were then later on, passed in the parliament. And several draconian legislations were enacted during this period. Just to give you two examples, one was the Monopolies and Restrictive Trade Practices Act, which in a way penalized any company for becoming big. And we know in economics that unless or until a company becomes big in size, it can't become efficient. It can't reap economies of scale. But the MRTP Act basically ensured that companies were deterred from increasing their size. Another very draconian legislation was the Foreign Exchange Regulation Act, or Fera. And one of the conditions of Fera was that any foreign entity which has more than 40% of equity stake has to divest it, bring it down to less than 40% if it wants to operate or continue its existence in India. Now, as a result, we know that several foreign investors such as IBM, Coca-Cola, Kodak, they all exited the Indian market because they were not willing to divest their equity. Now, all of this actually spoiled the entire business environment, the entire environment. The Indian economy, which had grown at a healthy rate of 5% in the first 15 years after India's independence, uh, uh, from 1966 till 1979, grew at a meager 2.5% or something like that for 15 years. So the Indian economy, which had actually started to look up after 200 years of colonial plunder, was once again back to a very slow growth rate from 1966 to 1979 because of these faulty economic policies, and of course because of several other political factors as well. Now, Mrs. Gandhi lost the elections after 1977, but when she came back in 1980, this time her approach was different. And in fact, in 1980, there was partial liberalization of the economy. There was a rethink in terms of how India needs to approach towards foreign investment. But overall, if one were to summarize this period from 1947 till 1990, one can say that this was a period which championed import substitution industrialization, which championed the idea of self-reliance or Atmanirbharta as it is called today, although maybe with a different connotation. Foreign investment or international trade was not seen as a very, very important vehicle of economic development. Now, in 1990, India faced a very, very severe economic crisis. The crisis was so severe that the foreign exchange that India had was enough to cater for imports of only 3 weeks. This was also a period of political instability. You had Mr. VP Singh becoming the prime minister for 11 months, followed by a short stint by Mr. Chandrasekhar, followed by midterm general elections being called in 1991. And then it was left to the minority government of Mr. P.V. Narasimha Rao to, to kind of find a way out of this mess that India had entered into. The 1991 budget in that sense was path-breaking, and it actually led or created or heralded a new era where India, there was a paradigm shift in India's approach towards economy as a whole, not just foreign investment. So a number of reforms were undertaken in the 1991 budget. Of course, all of this was done because of a very severe economic crisis. One very important reform was that several sectors were opened up for foreign investment. Several sectors were liberalized. Foreign investment, bar which was kept very low was increased. In several sectors, foreign investment was allowed through the automatic route, so on and so forth. And these economic reforms laid down the seeds of what I call as the second phase of India's bilateral investment treaties, the phase of acceptance. So how did India come to sign the first bilateral investment treaty in 1994 with the UK? The story goes that Dr. Manmohan Singh, after having presented his path-breaking budget in 1991, was in the UK, where he was meeting, foreign investors, British investors, inviting them to invest in India. One foreign investor asked him, what about the safety and protection of our investment in India? Because you don't have a bilateral investment treaty with any country. Now, Dr. Singh, being an economist, perhaps had very little understanding of bilateral investment treaties. So he came back to his office and finance ministry, instructed his officials in Department of Economic Affairs to look into what are bilateral investment treaties. And then after some homework, India signed the first bilateral investment treaty in 1994 with the UK. So I often wonder that what would have happened if those questions were not asked to Dr. Singh. So, many path-breaking changes that take place actually have a very, different kind of explanation to them. So since 1994, India then started to enter into bilateral investment treaties. And in the first 6 years from 1994 till 2000, India signed bilateral investment treaty with almost all major Western European countries that were investors in India: Germany, Netherlands, France, UK, etc. From 2000 onwards, India also started entering into bilateral investment treaties with developing countries, such as Argentina, Mexico, etc. So from 1994 till 2010, in the 16-year period, India signed close to 70 odd bilateral investment treaties. And if you take an average, as I argue in my book, it would be almost like 5 treaties per year. And this was a huge change for a country which had shunned investment treaties for almost 40 years, right? To sign almost 5 investment treaties per year from 1994 onwards. Now, there were certain characteristics of this period which I think are very important, and I'll quickly mention 2 characteristics. The belief in this period was that these investment treaties are important because they will enable India to attract greater foreign investment. However, it's interesting to note that no empirical study was conducted during this period. In other words, no one actually bothered to check that whether these investment treaties are actually leading to greater foreign investment inflows. So foreign investment inflows to India increased, and India signed investment treaties. But as we know, simply because 2 things are happening at the same time, we can't conclude that one is happening because of the other, right? So simply because foreign investment increased massively in India post 1991, and simply because India signed several investment treaties, one can't conclude that this was because of investment treaties. So there was no empirical research, empirical work on this within the government, outside the government, anywhere. The other important feature of this phase was that, barring one instance, no foreign investor brought a claim against India during this period. So the belief within the government and within the finance ministry basically was that, these investment treaties are like photo op opportunities. They are not something to be to kind of give a lot of attention to, because foreign investors have not brought claims against us. So there is nothing wrong with what India is doing, and India can carry on. It was business as usual. And I had a first-hand experience of this because when I was doing my PhD at King's, and as part of my field research, this was in 2010, when we were still in the phase of acceptance, as I later call it. Whenever I went and interviewed finance ministry officials or other government officials, and whenever I asked them that, are you alert to the possibility of foreign investors bringing disputes against India? And I always used to give the example of Argentina, because Argentina, a developing country by then, was flooded with several foreign investors bringing disputes against them. And the constant answer that I got was that, no, we are not Argentina. It may have happened with Argentina. It will not happen with us. One joint secretary even went on the extent to say that, you think you are the most intelligent guy. The lawyers of the foreign investors are fools. If there's any problem, they will definitely bring a claim against us, so on and so forth. Well, of course, at that time, I had no answer but to listen to them. And of course, it was more for my research. But post 2011, I can say that I had the last laugh. Because from 2011 onwards, what happened is that it kind of, India, which was in slumber in terms of investment treaty, suddenly realized that it has done something very, very significant, perhaps not realizing the significance of it. And the significance was that in 2011, a Australian company known as White Industries brought a case against India. This was on account of a commercial arbitral award which White Industries had obtained vis-a-vis Coal India. And the enforceability of this award, or whether this award is enforceable or whether this award should be set aside. This issue kept on languishing in the Indian judicial system for 9 long years. It was a football between Delhi High Court to Calcutta High Court, finally the matter landing in the Supreme Court of India. But just like any other case, it just kept gathering dust. And finally, White Industries decided they had had enough, and they brought the investment treaty arbitration claim against India. Now, this was the first time that India tasted something like this, and India lost that case. And the tribunal ordered India to pay damages to the foreign investor. And it was this case which resulted into all hell breaking loose. And India suddenly realized that, oh my God, these investment treaties are indeed very serious. And foreign investors can bring claims against us. And what that young doctoral student said to us in the office was perhaps right. This is just a made up bit. I don't know whether they said that or not. But yeah, this was my question to all of them. I was just finishing my PhD by then. Of course, I didn't have the opportunity because the arbitral award was not publicly available at that point of time. But after I submitted my PhD, this phase continued to roll on, and there were one after the other several claims that were brought against India by several foreign investors. Just to give you some examples, there was this very famous 2G telecom case at the Supreme Court, where the Supreme Court had cancelled the allocation of second generation telecom licenses on the ground of it being arbitrary. Now, in many of these cases, the licenses were given first to the Indian players. For example, a real estate company by the name of Unitech got a license from the Telecom Ministry. And then Unitech sold this license to a Norwegian company known as Telenor. Now, Telenor is a stellar telecommunication company with a very well-established reputation globally. Now, when Telenor acquired this license, Telenor had no idea how Unitech had taken this license. But when the matter went to the Supreme Court en masse cancelled all the second generation telecom licenses, and this included the licenses that were owned by several foreign investors. Now, these foreign investors suddenly were left high and dry, and this was the period, as you would recall, when there was a telecom revolution taking place in India. So this telecom revolution in a way started from 2005 2006 onwards, when we saw that mobile phones became very, very common, popular, etc. So several players entered the Indian market, but they all were left high and dry when these telecom licenses were taken away. And many of these telecom companies then initiated arbitration claims against India. Another example, I'm sure you would know because it has gone on for a very long time, is the infamous retroactive taxation case. This was, an amendment that was made in the Income Tax Act, retroactively imposing tax on Vodafone. Supreme Court ruled in favor of Vodafone and said that Vodafone doesn't owe a tax for an indirect transfer. And then the law was amended in order to ensure that Vodafone pays that tax. Likewise, a claim was brought by a company known as Kane Energy against India, again on the issue of retroactive taxation. These cases have played out. India lost both these cases. Only last year, India finally amended the Income Tax Act and did away with the retroactive amendment. And has returned the principal amount to these companies, but not the interest. But my belief is, or my argument is, that if India had not lost these cases at International Arbitration Tribunal, perhaps India would not have amended the income tax law. And unfortunately, it took India 9 years to correct this particular mistake. The third set of cases are the cases which were brought by Devas Multimedia, a company which was awarded spectrum licenses. Then these spectrum licenses were taken back under the garb of essential security, but the talk was that there was allegedly corruption involved. Devas was an Indian company, but it had got foreign investors to invest in that project from Mauritius and from Germany. So from Germany, you had the German Deutsche Telekom, a very famous company, investing into that project. And when these spectrum licenses were cancelled, these foreign investors brought separate claims against India. India again lost both these claims. India did not comply with the adverse awards. On the contrary, Antrix, which is the commercial arm of the Indian Space Research Organization, with whom Devas had first entered into a contract, they initiated proceedings against Devas, saying that their incorporation itself was for fraudulent purposes. The National Company Law Appellate Tribunal agreed with Antrix and said that incorporation of Devas was indeed unlawful, and the Supreme Court just a few months back actually approved this particular decision of the NCLAT. In the meanwhile, the Devas foreign investors are trying to attach Indian assets abroad because India has not complied with this award. So the last word on this has still not been spoken, because no matter what you do domestically, internationally you will still have to face the music for your actions. So because of these cases and because of so many claims being brought against India, India did two remarkable things. No, in fact, three remarkable things. The first thing was that India decided that it's important for it to review its existing bilateral investment treaties. Now, this is something which it should have done long back, because I had argued this in my thesis, that it is important for India to review its investment treaties. But India started the process after these claims were brought against India. Now, this review basically led to two tangible outcomes. The first outcome was that India decided it would unilaterally terminate all its investment treaties. And as a result, India has unilaterally terminated almost 70 odd investment treaties. Now, investment treaties contain a very important feature known as the sunset clause or the survival clause, which basically states that in the situation of any party to the treaty unilaterally terminating it, the treaty will nonetheless continue to operate for 10 or 15 years for the investment which has already come in, which means for the investment which has come in before the date of unilateral termination. So for all practical purposes, notwithstanding this unilateral termination, the investment treaties continue to remain operative in law for next 10 to 15 years. Now, this, in my view, was an overreaction on part of India. There was no need for you to unilaterally terminate, because it also sends out a very negative signal in terms of your respect for international law. The second tangible outcome was that India decided to come up with a new model bilateral investment treaty. Now, the problem with this model bilateral investment treaty, as I have argued in detail in my book, is that this investment treaty, instead of balancing or instead of reconciling the interest of foreign investors with that of the state, has actually taken the pendulum to the other end. So if India's old investment treaties were very, very investor friendly, and the pendulum was on this end of the spectrum, the model BIT has taken the pendulum to the other end, where it provides very little for foreign investors and only safeguards the state's right to regulate. Whereas in my view, the pendulum should be somewhere in between, which kind of reconciles the interest of investors and the state's right to regulate. Now, the proof of the pudding is always in the eating. So it has been almost 5 years or more than 5 years now. But India's model BIT is not acceptable to any major player in the world economy. So EU is not happy with the Indian model BIT. Australia is not happy. I don't know how will they include the investment chapter in the India-Australia FTA. Canada has certain reservations about the model BIT, so on and so forth. India has been able to sign new investment treaties based on the model only with countries such as Kyrgyzstan or Belarus. But these countries are not major players in terms of investing in India. So to conclude, and of course, then we can have question answers. India's entire journey of investment treaties that I have tried to condense in these 40 minutes from 47 till 2022 has been a story of not accepting investment treaties, to embracing investment treaties, to completely, kind of opposing them or unleashing a backlash against these investment treaties. Now, in my view, all these three phases, there has been a certain degree of overreaction. So when we started to accept investment treaties, we again started to accept them as if they were the most noble, innocuous instruments that India needed in order to attract foreign investment without undertaking the necessary empirical research. From 2011 onwards, instead of understanding why these claims were brought against India, we have turned our back towards investment treaties because we believe that these claims should not have been brought against India. But if you carefully look at each of these cases which I mentioned, each of these cases have come up because of India's poor regulation. I mean, if you impose a tax retroactively after losing a case in the Supreme Court, now, whether the Supreme Court was right on that point of law or wrong is a matter of debate, right? But even if, let's assume, the Supreme Court was wrong on point of law, you could have always amended your law prospectively. There was no need to amend the law retroactively, because it sends out a very negative signal that you, at the end of the day, want to target that one particular company as a bad loser, despite losing the case at the Supreme, at India's apex court. Likewise, if you look at India's, handling of the Devas cases. Now, if there was corruption involved in those cases, then India should have said upfront that we are cancelling these licenses because of corruption. And investment treaty arbitration tribunals are sympathetic to this argument. If a foreign investor is involved in corrupt activities, it is very unlikely that the investment treaty arbitration tribunal will give any relief to the foreign investor. They will deny jurisdiction. But India did not make the argument of corruption before the arbitration tribunals. And this is despite the new government coming into office from 2014 onwards. The hearings of both the Devas cases happened from 2014 till 2016, 2017. This was the time when criminal investigations were launched in this matter. CBI had also filed a charge sheet in 2016. But bizarrely, I don't know why, these arguments of corruption and fraud were not made before the arbitration tribunals. And by the time India made these arguments, it was too late. The tribunals had already given their decision in this matter. So, you can say it was a bad litigation strategy on the part of the law firm that was handling the case. But whatever may be the case, the final result is that there's a burden on the Indian taxpayer because of these two adverse awards. So in all these cases, it was actually India's poor, regulation which triggered these claims. And if India had got its act together, most of these claims would not have arisen in the first place. Now, my critique is that instead of analyzing the reasons why these claims were brought, India has taken these claims as an example that, this entire field of law is against our interests and we need to come out of it, or we need to, change our terms vis-a-vis this particular subject. Now, if any doctor undertakes a wrong diagnosis of a patient, then the treatment that will be offered will also be wrong, right? So in my view, the government has actually undertaken a wrong diagnosis of the entire situation. And as a result of which the treatment is also wrong in terms of, unilaterally terminating investment treaties, etc. So I'll conclude by saying that India needs to remain committed to investment treaties, but in a manner which strikes a balance between the rights of the investor with host states' right to regulate, rather than in a manner which gives precedence to the host state's right to regulate over the investor's rights. Because if you follow this template, then why will anybody who wants to invest in your country accept that particular template that you're offering to the rest of the world? So I'll stop here and I'll be happy to take questions.
Thank you, Professor Prabhash. We have a few questions already in the chat box, so we'll start with two questions that I can find from Utkarsh Kumar Mishra. He is in fact assistant professor working with Dharmshastra National Law University, sir. And he is also somebody who teaches international trade. And his first question is, can we say that non-inclusion of MFN clause also impacted the reception of India's model BIT? And second is, why is there a need for a new investment facilitation agreement when most of the traditional BITs used to cover investment facilitation provisions?
Okay, these are very good questions, Utkarsh. To answer your first question, yes, I'll say that non-inclusion of MFN clause has certainly impacted, how other countries receive or perceive India's model BIT. Now, India decided to do away with the MFN clause because of the White Industries case. Now, here again, India, in my view, learned a wrong lesson. You can have a MFN clause in the investment treaty, and at the same time ensure that it is not used for any kind of disruptive treaty shopping. I was part of the Law Commission of India, which drafted its report on the model bilateral investment treaty. That was the draft which Indian government finance ministry had put out before adopting the model. And as part of the recommendations of Law Commission of India, this is what we had recommended, that if your concern is that investors should not use MFN for disruptive treaty shopping, you can design the MFN clause in such a manner that it is not used for that purpose. But not having the MFN provision at all in the investment treaty would mean that you are basically giving a signal that we can even discriminate between foreign investor from country A vis-a-vis country B, and the investor will have no recourse. So that, I think, is definitely a problematic aspect. Regarding your second question about investment facilitation, I have a slightly different take on this. If we look at the first generation investment treaties, they actually do not cover investment facilitation provisions. They are generally geared only towards protection features, not facilitation features. So therefore, investment facilitation agreement, in that sense, becomes important. But the question is that where do you want to have the investment facilitation agreement? So one option is that you have it as part of your investment treaty and you call it as the investment treaty, which talks of both protection and facilitation. The other option is that you have it as part of, say, the WTO, the World Trade Organization. And in fact, there are already attempts, as you would know, of having an investment facilitation agreement at the WTO, which will only contain facilitation features and not protection features. Now, India is against these, this facilitation agreement at the WTO. Although I feel that there is no harm in having a facilitation agreement as long as it does not include protection features at the WTO.
Thank you, sir. Thank you.
Thank you. Another question we have from Dr. Prasenjit Kundu. He is an assistant professor working with Dr. Ram Manohar Lohia, National University, Lucknow. And he teaches international arbitration, commercial arbitration. And his question is, Union of India versus Vodafone, in the Indian court's decision that Indian courts do have personal and subject matter jurisdiction over disputes under an international investment treaty. Don't you think that such decision amounts to wrongful interference by the domestic court with an investor's right under an international investment treaty?
Prasanjit, that's a difficult one to answer. Yeah, you can say that it amounts to an interference, which the investor would definitely not like. But if the investment is made in a particular jurisdiction, say in India, and if the matter goes before the court, I don't think the court will say that since this matter will be governed or is governed by an investment treaty, therefore we are not, we completely wash our hands off from something like this. But I guess what you're referring to is that there are instances where the Indian courts will grant what are known as anti-arbitral injunctions, basically stopping the foreign investor from pursuing the investment treaty arbitration claim. Now, that definitely is deeply problematic, because issuing such anti-arbitral injunction in itself can be a ground for the foreign investor to bring a claim against the state, because judiciary is part of the state as far as international law is concerned. And if I may also add, with due respect to our honorable judges and our lordships, I am not very confident the extent to which our judiciary is able to appreciate international law in general and international investment law and international trade law in particular. And that lack of a fuller understanding, and the same will go for domestic lawyers who argue before these tribunals, the star advocates and all those people. Their own understanding of international law is the less said the better.
Yeah.
Now, as a result, what happens is that when these claims go before the courts, perhaps they don't get the right argument or they don't get the right information, and therefore it ends or leads to erroneous decisions. And this is precisely, as you rightly say, happened in the case of Vodafone.
Yeah. Yes, sir. Yes, Prasanjit has also asked a question. What is your take on the applicability of Arbitration and Conciliation Act to an investment arbitration?
Yeah, so again, the Indian judiciary has created a bit of an issue of this. I mean, there's no Supreme Court judgment on this, but there are three High Court judgments, two by Delhi High Court and one by Calcutta High Court. And as per the reasoning of the Delhi High Court, the Arbitration Conciliation Act does not apply to investment treaty arbitration. Now, this again is, is quite problematic because then which law applies? So then it would mean that it would be a case of any investment arbitration being governed by the Civil Procedure Code, or things like that, which will obviously create a lot of problems, not just for the investor but also for the state.
Even in that case, we will have difficulty in the enforcement of that arbitral award, that investment arbitral.
Absolutely. So because the Arbitration Conciliation Act was designed keeping the enforceability of arbitral awards. Now, there is merit in the court's argument that investment treaty arbitration is not an extension of commercial arbitration. The nature of investment treaty arbitration is different. It has similarities with commercial arbitration, but there are important divergences or differences as well. For example, investment treaty arbitration has its roots in public international law. It involves public law questions, such as sovereign, the state sovereign right to tax and so on. So whether Arbitration Act is the right one to apply, but if Arbitration Act is not right one in the current form, then maybe an amendment should be made and a separate section or a chapter could be added, which would say that this part applies to investment treaty arbitration specifically. But that would require a legislative enactment, or we have to wait for the Supreme Court to make sense of these decisions and then give us the law that whether the Arbitration Conciliation Act applies to investment treaty arbitration.
So precisely right now, we do not have any law governing this issue, like the enforcement of the investment arbitral award. Because before this Delhi High Court decision, like usually we used to apply this Arbitration Act for the enforcement of the investment arbitral award, and there is no Supreme Court decision. So what is your takes, or what is the now law which is here in India in regard to the enforcement of a foreign investment arbitral award?
Yeah, so currently it's in a state of flux. I mean, you can argue, on the one hand, you can argue that Arbitration Conciliation Act still applies to investment treaty arbitration, notwithstanding what Delhi High Court said in the Vodafone case. But on the other hand, again, if we go by what the Delhi High Court has said, then Arbitration Conciliation Act is only for commercial arbitration, not for treaty arbitration. So there is a bit of a vacuum in law as of today. Now, there are two ways to go forward. Either the parliament takes note of this and corrects it, which I don't foresee happening, or the Supreme Court clarifies this in a future decision.
Thank you.
Thank you very much, sir.
Thank you. So the next question is by Lokesh Kumar, and he has asked, what are your suggestions for proper regulation of BITs instead of unilaterally terminating BITs and coming up with a model BIT?
Yeah, Lokesh, that's a very good question. So my suggestion would be that you try to renegotiate the existing BIT and try to replace the existing BIT with a new BIT. So there is no harm in coming up with a model BIT. In fact, having a model BIT is a good thing because it helps your treaty partner countries to know where you stand on various issues. So there's no harm in having a model BIT. But the harm is in terms of how that model BIT is structured or designed. If the model BIT is very state friendly or very investor friendly, then both the extremes are problematic. So in my view, the Indian model BIT is very state friendly. It does not offer enough for investors, and therefore the countries which are capital exporters to India, they will not be interested in this model BIT. Likewise, India of today is not India of 40 years back. Now you have several Indian companies that have started to invest abroad. Now you would require protection for your own investment abroad. And if you have a model BIT which is very, very state friendly, then providing protection to your own foreign investors abroad will suffer. So therefore, my solution or my advice would be that you identify the investment treaties, tell countries that we will renegotiate them in order to take into account, or in order to strike a BIT which balances investment protection with states' right to regulate. But now this is just a hypothetical scenario because India has already unilaterally terminated these investment treaties. This is something which should have been done 4 or 5 years back.
Okay, thank you. The next question is by Swati Parmar. She is also an assistant professor at DNLU Jabalpur. and she is asking about as to whether the courts, in particular in India, know the implications of international investment law when they are delivering their verdicts. And she has also asked that we do not pay much attention to the international investment law finding a place in the curriculum of law schools in India. Is there a study on the judge's understanding of international investment law who delivered Devas and Vodafone judgment?
Swati, so to answer your last question first, there is no study to the best of my knowledge, but there should be a study. So if some researcher,
Prasanjit?
so if some researcher is looking for a new research or a PhD topic, this can be one such topic, and not just restricted to Devas and Vodafone judgment, but to kind of look at overall, how the judiciary looks at investment treaty arbitration, and a good empirical study will be very, very useful. So as I said that, the understanding of judges on this question is doubtful. And the reason for that is undoubtedly, as you rightly say, that international investment law does not find, a prominent place in the syllabus of law schools. In fact, even today, I have been working in this area in India for now almost 15 years. If I count my started in 2006 as part of my LLM dissertation. So if I count from 2006, it's almost more than 15 years. And even today, I will struggle to name 10 academics who actively, there might be many who might be teaching, right? But 10 academics who are actively writing and doing research in this area, I'll struggle to name even 10 people. Now, this is quite shameful for a country as big as India, which has so many law schools and so many law academics. So there is definitely need for capacity building. And I link this with the larger body of international law, not just international investment law, because international investment law is part of international law, right? So even the area of international law, as we know, does not get the kind of attention that it should get in our law schools. This is changing. There's several young academics who are coming up, like you, like many others, who are writing in this area. So this is changing for sure. But the pace needs to be accelerated, and for that, it's important that the people who run the law schools give specific importance and prominence to international law along with other subjects.
Thank you. Thank you, sir. I just wanted to tell you that we also wanted to introduce international investment law as an optional in our BA/LLB curriculum. But we have this rule that only if 20 students opt for the subject will be offered. And unfortunately, we did not get 20 takers among a batch of 120. So we will have to look for new ways to ensure that we make international investment law part of the curriculum of BLLB honors here at Jabalpur. I also have a question. Like you informed us that that there is a sunset clause in the international bilateral investment treaties, and India has unilaterally gone ahead and terminated its BITs. But in effect, legally, those BITs are still in operation. So is there, with now coming up with a model BIT, if suppose from a dispute arises in respect of those bilateral investment treaties, which India has gone ahead and terminated, is there an argument available for India that now we have terminated it, and as a measure, as a substitute, we have come up with a model BIT, or is it something is altogether an argument which cannot be accepted at those forums whenever an issue comes up?
Yeah, Manvendra. So the model BIT does not have any legal standing, because it's a unilateral instrument. It's you can say it's a policy statement. So it's basically a policy statement. So it's like a model law. Like if say the government lays down a model law encouraging states to enact laws based on that model legislation. That model legislation in itself can't be enforced in courts, right? So the same goes with the model BIT, that model BIT on itself cannot be enforced. So if a dispute crops up between the foreign investor from a country whose investment treaty has been terminated, and mind you, it should be for investment that had already come in before the termination. So if any investment comes in after the termination, then that investment will not enjoy protection under the investment treaty. But for any investment that had come in before the termination, the investment treaty is still available to the foreign investor to seek protection for its investment. So the model BIT here will play no role, because the model BIT is, like, as I said, merely a declaration of intent or a policy in that sense.
I'm curious to know whether the declaration of the Indian government terminating the BITs, whether it takes into account this fact that so far as the existing investment is concerned, the termination will have no bearing.
I presume that they they are alert to this possibility, because that's a very clear provision in almost all investment treaties, that this will have no bearing on investment that has already come in, and that investment will continue to enjoy treaty protection. For example, Devas has brought a new claim against India after the Supreme Court ruling, a new BIT claim, and although India Mauritius investment treaty has been terminated, unilaterally terminated. But Devas's argument is that since my investment was made before the termination, therefore the India Mauritius BIT continues to apply. Now, how the government will respond to this argument, etc., that remains to be seen. But this is an example of what I was talking earlier.
Okay. That's really it's an extraordinary thing. I was just wondering that the executive has lost its case before the Supreme Court, and for the Supreme Court's judgment, the executive is actually accountable in a BIT for a cause which it was actually contesting before the Supreme Court and having lost it. So that in itself is also for students of public law. I
Yeah,
guess these are very important and very significant questions to look at.
yeah.
Yeah.
No, in fact, Manvendra, if you just permit me for 30 seconds,
Listen.
when we talk of international investment law, one way to explain the importance of this subject to students is by pitching it as part of a package deal, in the sense that if a student is interested in arbitration, and I presume that several students will be interested in arbitration, because arbitration is a lucrative career practice, etc., etc. Now, students need to be told that if you're interested in commercial arbitration, you cannot become a good arbitration lawyer till you have a good understanding of investment treaty arbitration. And when you talk of investment treaty arbitration, you are then talking of international investment law. So, one way to see, we have to make our products sell. I know I might be sounding a bit like, so one way to make your product sell is by pitching it or packaging it in a manner that will appeal to the customers, if I may say so. So one way to do that is that instead of calling it international investment law, call it investment treaty arbitration. And it's the same thing, right? And when you pitch it as investment treaty arbitration and then link it with arbitration as such, and also link it with public law, as you are pointing out, in terms of Supreme Court judgment being challenged, or a legislation enacted by the parliament being challenged. So it's a kind of an international judicial review. So you will be able to link this not just with arbitration, not just with trade law, but also with larger body of public law. And the moment students are able to see these linkages, I am very confident that you will get more than 20 people.
Thank you. Sir, we have a last question which we'll take for today. The student Anand Abhishek, he's talking about now that we have a new BIT, and the backdrop of this coming of the new BIT obviously is not the one which instills trust in the government's measure so far as attracting foreign investment is concerned. So where do you see foreign investments as something which a country like India is hoping for vis-a-vis model BIT?
Yeah, so Anand, that's a very good question. My argument is that there is a bit of a dichotomy between what India is doing. On the one hand, India is very adamant, or is kind of sort of speaks very highly of attracting foreign investment. You know, if you look at the speeches of Prime Minister, the Commerce Minister, Finance Minister, all of them emphasize on how foreign investment is very important. All of them emphasize on how India is attracting foreign investment, so on and so forth. But on the, on the other hand, when it comes to using this instrument of investment treaties towards that objective, the messaging is that India has a very restrictive, inward-looking investment treaty. Now, this is definitely a dichotomy which may have an impact on India's attractiveness as regards foreign investment. Now, what ails India's model BIT, as I have mentioned earlier, there's several things. I have a full chapter in my book where I analyze this. But to put it very briefly, the biggest flaw is that India's model BIT is very, very state friendly. So it does not give adequate protection to foreign investors. Now, if it doesn't give adequate protection to foreign investors, why will a EU or a Canada or Australia or any of these countries which are major exporters of capital to India, why will they sign an investment treaty of that nature? That's a very simple question. So India has to revisit its model BIT. And in fact, recently there was this External Affairs Parliamentary Committee report. I had appeared before that committee as an expert. And the parliamentary committee has also asked the government to revisit its model BIT. But then we know that parliamentary committees make several recommendations, but then they just keep gathering dust and nothing much happens. So.
Thank you. Thank you, sir. So I guess with this, we have come to the end of today's program. And we cannot thank Professor Prabhash Ranjan enough for having given us time and and his eloquence, especially on the subject of India and bilateral investment treaty, is otherwise well known to all of us. But today we got the opportunity to witness this as well. And with this hope that we'll have him on future occasions as well to enlighten us on some of the associated issues of bilateral investment treaty. We thank all the participants who have joined us for this event. Thank you very much, and thank you for joining, and we'll hope to see you soon with other dignitaries, including Professor Prabhash Ranjan. Thank you all.
Thank you very much. All
Thank
the
you,
very
sir.
best.
Thank you.
Bye-bye.
Bye, sir.